Hi, my name is John Goralka. I'm the founder of the Goralka Law Firm. Our firm is unique in that we focus and specialize solely on estate planning, business, and tax issues. I'd like to talk to you today about estate planning in 2014. Many changes have occurred in both the law, estate, and income tax issues that may cripple your estate plan. One of the first concerns we have involves HIPAA. In order for your successor trustee to be able to get access to your accounts, your successor trustee needs to be able to obtain basic medical information from your physician to show that you're incapacitated. A simple HIPAA authorization authorizing your successor trustee to act isn't really sufficient. And the reason why is if your successor trustee himself or herself becomes incapacitated, someone needs to be able to get medical information not on you, but on your successor trustee in order for the next in line to act. So you need to have a very broad HIPAA authorization to provide for that. Older plans simply don't have the required forms. The other issues really involve the income and estate tax rates. For many years, the estate tax rates were substantially higher than the income tax rates. Now, in 2014, the world is upside down. The income tax rates, in many cases, significantly exceed the estate tax rates. Also, we now have a $5.34 million estate tax exemption. So the estate tax really doesn't apply to maybe 99% or more of the public. However, the income tax rates unfortunately apply to us all. It's very, very important that we plan to provide for a basis step-up for each of your beneficiaries. Basis step-up really relates to getting an increase in the income tax basis for assets that are going to be sold. For example, if I bought a home for $100,000 and I sold it to you for $500,000, you would be paying capital gains on that on the $400,000 or the difference. Unfortunately, here in California, we have some wonderful weather, but we also have the second highest capital gains rates in the nation. On the other hand, if I have the same home and I sell it to the same person for the same $500,000, but instead of having bought it for $100,000, I inherited it from my father when it was worth $500,000, now I have a basis step-up equal to the fair market value as of the date of death. And so now when I sell that home, I keep the entire $500,000. I receive the basis step-up. Many older estate plans were focused exclusively on minimizing or avoiding estate tax, which also results in a higher propensity for capital gains because you don't get the required basis step-up. Older plans should be reviewed for that purpose as well. Another area that is really a problem that I see every day in my office are marital formulas. And what that really relates to is when a husband or wife pass away, when all the assets go from one spouse to the next spouse and then to the children, which virtually all of our clients seek in some form, the estate tax system actually has a penalty embedded in that. That penalty can be very substantial. As I indicated earlier, each of you have a $5.34 million exemption. That penalty was actually the amount of that exemption, or $5.34 million. And the interesting thing to note is while we have a very high exemption rate now, not too terribly long ago, the estate tax exemption was only $675,000. The estate tax rates were over 50%. Many estate planners were very worried about avoiding estate tax under any circumstances. So they would create a formula, and it's often referred to as an A-B trust. You may have heard that term. And so the way an A-B trust works typically is one half of the marital assets, or the one half that were owned by the surviving spouse, stay in an A trust. And an easy way to remember what the A trust is, it refers to the person who is above ground. And that A trust is completely revocable. The surviving spouse has full access to the income, full access to the principal, and then also has a full estate tax exemption upon her death. Also, the children receive a full basis step-up on the death of the mom. However, the problem is in the deceased spouse's one half. One half will automatically be allocated under many marital formulas to a B trust. An easy way to remember that, unfortunately, is B might relate to the person who's below ground, the person who's deceased. The B trust oftentimes, but not always, will provide full access to the income. Sometimes I even see limited access to the income, which can also create tax problems because the income tax rates for trusts are significantly higher than the income tax rates for any individual. More importantly though, most or virtually all B trusts will have significant limitations on the access to the principal by the surviving spouse. And that, for us, is a very difficult conversation. We handle many trust administrations, and it's a very difficult conversation to have with the surviving spouse when I tell him or her that approximately 1/2 of the assets that he or she thinks she owns or he owns, they don't really own anymore because it's now in this B trust. And so that, again, that's a problem. But even beyond that, we have tax issues with respect to that. If capital gains transactions occur within that B trust, they may be trapped because of the trust accounting rules to be taxed within that trust, again resulting in a higher tax rate. Then also, aside from that, now when the surviving spouse passes away and the children sell that asset or the other loved ones, I have the pleasure of telling them that they get a full step-up in basis in the assets that were in the A trust, but no step-up in basis in the assets in the B trust. Again, a difficult conversation. And the problem is let's say the combined estate is $5.3 million. And remember, I said that the estate tax exemption is $5.34 million. So we've incurred all of this additional complexity, all of the additional requirements for separate income tax returns for the B trust, and all of these significant income tax costs, and we've not saved one single dime in estate tax. The problem is that with these marital formulas, it's just like a light switch. And just like a light switch, once it's activated, and I may push it intentionally to turn the lights on, or I may bump that switch with my elbow and not intending it for it to happen. And either way, the lights go on, the switch is activated. The same is true with these marital formulas. And the problem with the marital formulas is once there's a death, it's automatically triggered. The B trust becomes irrevocable. There is a formula that will be embedded within the trust itself, which tells the trustee where the assets have to be allocated. A very difficult proposition. A much better approach, and the approach that we have always used, is what we call a flexible AB trust. And what that is it provides for all of the assets to go to the surviving spouse, and then he or she actually has 9 months to decide whether to fund all or any portion of the assets into the B trust. A much better approach. And also now, finally in 2013, we actually have a Band-Aid or a temporary fix to this problem regarding the marriage penalty. And this Band-Aid or fix is really called portability. I call it a Band-Aid because while it's there and it's a huge improvement over the past, the problem is that it's not automatic. And what basically happens with portability is when all of the assets go from the deceased spouse to the surviving spouse, now there's a mechanism in place to provide for that large exemption to also flow from the deceased spouse to the surviving spouse. But unfortunately, in order to claim that exemption through portability, an estate tax return has to be filed, even though an estate tax return may not otherwise be required. The IRS estimates that more than 90% of the persons that would qualify for portability will fail to file the required returns. So this is an issue that actually has a fair amount of complexity in order to determine what the most appropriate approach is to minimize your estate and income taxes. So again, that's something that needs to be looked at for any trust that has been prepared prior to 2014. And then also now, just like cell phones and televisions and TVs and cars, technologies have also improved. And now what we're able to provide for is a personal asset trust or a mini asset protection trust to protect the assets that flow to your children or other loved ones. And so those assets are actually provided in a format so that it's significantly enhanced to protect from divorce, from lawsuits, and from creditors. Again, that's a significant improvement over years past. One of the other problems is planning for individual retirement accounts. And the problem here is that as many people really misunderstand the choices that are available for retirement accounts. And first, in order to evaluate that, the real benefit for these retirement accounts is that they are able to grow on a tax-deferred basis until the holder attains the age of 70 and a half. After 2013, the IRS issued regulations that loosened the requirements for inherited IRAs to also qualify for this tax-deferred treatment. In order to qualify, typically the beneficiary must be an individual. Trusts can qualify, but they need to have very special and somewhat complicated requirements satisfied in order to qualify as a designated beneficiary. And so the other issue, though, is asset protection. For your individual retirement account, you have some limited protection through bankruptcy because it's considered to be a retirement fund. Unfortunately, though, the same characterization will not pass through or qualify for an inherited IRA. The Supreme Court just ruled approximately 1 month ago that inherited IRAs do not constitute retirement funds and therefore do not qualify for asset protection. So if you want to protect the funds within the IRA account after they're going to your children or other loved ones, you need to utilize a trust to act as a beneficiary to provide that asset protection. A trust is also very helpful if you're concerned that your children or loved ones suffer from what I call the instant withdrawal system. In other words, if I pass away, will my son access my retirement accounts immediately so that he can quit college and begin an extended spring break? That is a concern of mine. And so what I'm able to do is provide for my children's retirement accounts to continue to grow on a tax-deferred basis, but restrict their unlimited access to those until my sister or my brother Joe thinks is appropriate, or they attain the age of 45. At the age of 45, I think at that time they will be more concerned about retirement accounts, and I think they're better able to look at the long-term benefit. And also, I think the reason why this is very, very important is I think for the first time now that we are actually concerned about whether our children will actually be better off economically than we were. And I think that is also part of the American dream. And now we are seeing that erode away in terms of home ownerships and also with respect to retirement accounts. And just like medical plans and those sorts of things, we're seeing many companies restrict the availability of retirement accounts for the employees. So many of my clients are very concerned about establishing systems so that they can provide for their retirement benefits to pass to their children on a tax-deferred basis, and also to protect those funds from divorce, from lawsuits and creditors. Click here to subscribe and see more videos on asset protection, estate, and tax issues.